Good morning. Can you all hear me? A nod from anyone who's on is appreciated. Okay, great. My name is Camille Jackson. I am the co-chair of the Grantee Training Committee and a member of the Bar Foundation, and would like to welcome all of you all to the second session. This morning, we're joined by two very special guests who will present and we always have great feedback when these two gentlemen present, and I know today will be no exception. I will introduce to you both Skip Phillips and Edmund Gearing. Edmund's the current treasurer of the Bar Foundation and the soon-to-be vice president. He is general counsel for the Baton Rouge Area Foundation. Skip Phillips is a past president of the Bar Foundation. He is of counsel at Taylor Porter in Baton Rouge and is going to be honored this year as our Bar Foundation Distinguished Attorney. So without further ado, I will hand this over to you gentlemen, and thank you very much for leading us in our discussion today.
Thank you, Camille. And I want to say for the group, special thanks to Camille and Dave Ernest, who chair this committee. This grantee and staff training came out of a series of events that we held back in 2014. Skip and I were reminiscing a little bit yesterday about kind of the history of this presentation. And we traveled around the state in 3 or 4 sessions to convene funders and groups that were grant recipients of the Bar Foundation to talk about issues that were important to each of those organizations at some level, and certainly things that were of interest to the Bar Foundation as we were the funder. That turned into a very successful tour, if you will, that sparked an annual, or at least we thought, well, let's do it again. And we did. And as we moved forward, this committee came out of it, and I'm either I get credit or I get blamed for that, because I suggested it just off the cuff at a board meeting, and we voted, and the committee was brought into existence years ago. And so now we have taken this on an annual basis, and I know that many of you have participated with us, and we appreciate it, and we certainly appreciate the feedback as we have tried to keep the materials relevant, but also understanding that while we do have some veterans who are attending for the second or third or numerous time, we also have folks who are new to this training. And so some of this will be familiar, others of it we hope to be new, and we've provided essentially the same information that we have in the past, but with a slight twist. Today, I think what we're going to try to do is to cover the areas that were provided to us as areas of interest this year, and that is looking at bylaws and governing documents, talking about board engagement and relationships between the board itself and the executive director, and how that relationship ought to look. You'll find in the presentation, which I know that Renee has distributed, and also want to give a special thanks to Renee for all of her assistance in getting us ready to be here both yesterday and today. We're so grateful for that. And we have a PowerPoint presentation that you will see today and will be available for you to review in the future. And in that, you'll see essentially 3 sections, as we talked about: what your duties and responsibilities are as a board member, what your what board engagement looks like, and that could be everything from fundraising to monitoring the performance of the executive director and the staff. And then finally, just the old standby information as to the IRS Form 990 and how important it is. We've really covered that in great detail in past years, so we've moved that to the end of the presentation this year. We'll certainly answer any questions if we don't get there through all of those slides. But we're really trying to focus more on the board engagement piece this year. So I will be looking at the chat, as I know Skip will, and we will. And Skip, I'd love for you to provide any comments before we jump into this, because you certainly have a different perspective on this. Well, maybe Skip has not joined us yet. That's okay. I can take it. Okay, in any event, we will go ahead and get started. As you see, we've entitled this Duties and Responsibilities of Board Members. And I am always pleased to talk about this topic. We've had a lot of experience with this in both our volunteer work and in my personal journey here at the Baton Rouge Area Foundation. And so I hope that you'll find this information helpful. Please do monitor or jump into the chat if you have any questions. And I know that Renee will also help me to try those. What we're going to do, and I hope to be able to answer questions throughout. I would like to keep this conversational, which will be a little bit of a different format. Okay. And Renee is running the slides for me, so bear with us as we get our rhythm down, but here we go. Renee? I always like to say, and I know Skip does as well, that while we're not providing any individual legal advice, we hope that you find this helpful. We can't address any particular fact circumstances, although we're happy to answer questions, and certainly any of the tax information that is provided is not tax advice and or legal advice. So you would be wise to consult with. I know all of you have access to attorneys, ironically enough, since we're here for the Bar Foundation, but you would be wise to consult in those situations. Next. So the duties of a director of nonprofit corporations, they are not significantly different from the duties of a director of a for-profit corporation or a limited liability company. In most instances, those duties are imposed by state law, and they can be enhanced or explained or in some ways changed by your individual bylaws. And so one of the things that Skip and I always stress is when you are asked to be a board member of a nonprofit or for-profit for that matter, it is always important to ask to look at the governing documents. That would be the articles of incorporation, the bylaws, any written policies or procedures that have been put in place that are essentially in the purview of the board. One, you want to know what it is that you are subject to and what it is that you are agreeing to get into. These are not ceremonial positions. In fact, I know in most cases for the grantees, these are working boards. And yes, while they rely on your professional expertise, there are some responsibilities that come along with that. Next. So you owe a fiduciary duty to the corporation or to the entity. As I said, it's not ceremonial, it's not honorary. It is a serious undertaking, and a breach of certain types can result in liability to you, and in most instances, in some way, damage to the organization. So what does fiduciary duty mean? It's necessary to put the obligations of the corporation ahead of your personal interests. So that means that you have to be loyal to the organization. We use these words sometimes: judgment, diligence, reasonableness. What do those mean? Most people have their own personal definition of what those things mean. And I would tell you that in most instances, that personal definition is okay. It's spot on. We all tend to know what it means to be loyal. We all tend to know what care means. And I think we all have a really good understanding of what good faith means. So those are, as you see there on the slide, those are the three main descriptions, but the duties are loyalty, care, and good faith. Care is interesting because, again, you get into using judgment. Your diligence, meaning investigation, you've looked into matters that are under consideration, and you bring a certain level of skill that an ordinarily prudent person or a reasonable person would exercise under similar circumstances in like positions. So if you gave an issue to a large group of people, most people would tend to decide an issue one way as opposed to another. That would be reasonable. That'd be ordinarily prudent. That'd be reasonable care. And certainly good faith means you are keeping the interests of the corporation in mind. What all of this kind of overarches is the fact that you can't put your own interests ahead of that of the organization. And that this is typically not an issue for most people. But there are circumstances under which a director may be called upon to undertake some work or undertake some project, and certainly it could be a paid project. And we're going to talk about conflict of interest, but it would be a situation where the interests of the director could be ahead of the interests of the corporation, and that's where disclosures come into play. That's where conflict of interest policies come into play. And it's making certain that there are no secret dealings, there are no underhanded maneuvers, that an organization is not being in some way impinged upon or hurt by the actions of its own director, who would be putting their interests ahead of the other. I'm gonna pause there because I did get a note from Skip saying that he was trying to get in and it was having some difficulty on his end, not our end. But I wanted to just pause and say, Skip, are you with us yet? Okay. He will hopefully let us know and jump in and correct me at any moment when he does join. Next slide, please. That I probably already said this, but put another way, those loyalty, care, and good faith means a director should exercise the same degree of care, inquiry, and good faith in discharging the duties of a director as that person would exercise in dealing with his or her own affairs. That really sums it up for most folks. Just to act the way you would act as if it were your own. Loyalty, here we go, getting a little bit deeper into it. Again, no conflicts of interest, no self-dealing. When the time is appropriate, or those transactions or those interactions call for it, it should be disclosed. That's what the conflict of interest disclosure statements are about. In most instances, organizations will distribute these on an annual basis. We at the Bar Foundation actually do disclosure at each board meeting because we meet quarterly. So we have the opportunity to disclose anything that may have come up in the last 3 or 4 months. And if appropriate, a director who does have a conflict of interest, or at least the appearance of a conflict of interest, should recuse themselves from the transaction and also the discussion of
what was the issue?
The transaction.
Okay. Well, Edmund, for better or worse, I made it.
Well, it's better for all of us, Skip.
Well.
I'm sorry you had trouble. We're clicking along a little bit.
You know how technologically adept I am, so no chuckling and snickering out there. But you're doing just fine. Keep going.
We're about 4 slides in. You want to take a few take a minute to talk about this, because I know this area of loyalty, care, and good faith is of particular interest to you.
Yeah, I think you hit on some of the important points here. One, obviously, while it is an honor to be selected to serve as a member of these boards, the boards that are of our grantee organizations, it's not an honorary position. There's a lot of responsibility that comes with it. And the whole idea of a fiduciary duty is what drives this. And very simply, it's just to put the interest of the organization ahead of any personal interest you might have. And we don't very often see conflicts between those things. But if you hold that thought in mind as you're voting on issues and deliberating and discussing issues and always thinking about the mission of the organization and what's in its best interests, you'll be just fine. And I see that you were about to talk about care. And to me, this topic is simply to participate, to be informed, to ask questions. Nobody is going to get offended by a director asking questions, and nobody in a good organization is ever going to be offended by that. And it's really not a criticism of management. It is simply an extension of your obligation, because after all, you're charged with the well-being and the governance of the organization, and it is very difficult to do that without being informed about what's going on. So when presented with a proposition, for example, it's really your duty to make sure you understand it and to ask questions if you don't understand it, and make sure that you have a really good fundamental factual basis for making a decision.
You know, Skip, I was reminded of this in some instances. New directors, brand new to an organization's board of directors, will come into a meeting and are typically pretty quiet for about a year. If they have a multi-year term, they will sit and listen. And there's certainly nothing wrong with that. That is not a requirement of board services to sit quietly and listen to the veteran directors. As Skip said, asking questions is the best way to learn more about the organization and quite frankly, the personalities of the staff and the other directors, if it's something that you're not extremely familiar with. So it's interesting how, as we have started to think about this from the standpoint of, it's easy to talk about what these obligations are of director service, but it also translates somewhat into what we're going to talk about in a few minutes, which is board engagement and what's appropriate engagement for a director. And Skip's exactly right. I mean, showing up is the first part, but showing up is not everything. Just being in the room just means you were in the room. But participating in the conversations, participating in the diligence and the investigations, I think are all critical aspects of board service.
You know, and I would also add to that, Edmund, for the veterans in the group, always veterans on the board who are welcoming new directors to the membership. One thing that you can do to enhance the performance of your organization and the governance of your organization is to make it a point to onboard and educate your fellow board members, so that you don't end up sitting there for a year trying to figure it out for yourself, right? That's part of the onboarding process. So when we talk about knowing the mission and knowing what the governance documents look like, the articles of incorporation and the bylaws, the chair of the board and management, that ought to be part of their obligation to the incoming board members as they're becoming more engaged. Make sure that they're educated, right? We don't want to just put you out there and say, welcome to the board, you bring the donuts to the first meeting, and now figure it out for yourself. That's not good governance for the body.
That's right. That's exactly right. And I think as we go through this, again, while we certainly rely upon the slides that you see in front of you, Skip and I will try to add as much color based on our own experiences in board service and in some cases in some of the clients that we've represented with respect to board of directors and board service.
Or boards that we have been on, right? Right. I mean, sometimes the more complicated, the more the fiscally large an organization is, the more important this becomes. So if you're on a board of a $1 billion nonprofit corporation, that's going to take a whole lot more learning than if you're on a smaller organization with smaller dollars and smaller mission. But the principles are the same, and you still have the same obligations. So, just keep in mind that take the job seriously, ask questions. Certainly okay to rely on management, as we're going to talk about, but that has its limits. Make sure you are satisfied, even if the position you hold may not be the position that everybody in the room holds, if it's not the most popular one. It's okay to have a different view of the world when it comes to making decisions as a board member.
That's exactly right. As we move into good faith, I think we really covered this just a few minutes ago. It is really, it's very, very straightforward. A director should have no ulterior motives and should always have the best interests of the corporation in mind. And it does happen that there are times when there are conflicts. It does not mean there's not good faith. It just means that there is the potential for some conflict down the road based on the current circumstances. And those circumstances can be either mitigated or eliminated, as we said, by the use of disclosures and recusals. And those are ultimately the two tools. And I guess the third is simply resignation. And we'll talk a little bit about that later. But to avoid anything that would make it appear as if a director is acting in bad faith or in their own best interests.
I would say that, and just beyond the fact that that's a violation of a driving principle of governance, there's some exposure to a director who acts in bad faith or for an ulterior purpose or to benefit themselves financially, for example. There could be some legal consequences for that kind of activity. So there's more, if you need another reason to do it and to pay attention, that would be it.
Yeah, that's exactly right. Renee, next slide, please. Yes. And so here we go, leading right into Skip. Skip, why don't you take this one since you started?
Sure, I'll try to finish it. So you may be asking yourself, and listen, when most people are approached about being a director, particularly in an organization in which you've been working, or that with which you're familiar, or in whose mission you strongly believe, it is unusual for someone to say, well, what should I be looking out for? What liability might I be incurring? Most of the time, the directors to be, the recruited directors that we deal with, are anxious to serve. They want to serve. But it is important for us to all know that there is some potential liability. And this is liability that attaches to just the status of being a director, whether it's a for-profit or not-for-profit organization. And so what happens, you may be asking yourself, if I make a mistake as a director, or if the board makes a collective mistake as a director, does that mean I'm going to be asked to resign? Am I going to be thrown off the board? Am I going to have to write a check to somebody? And the answer to that is generally no. While there are sanctions for breaches of fiduciary duty, we apply what we call the business judgment rule to evaluate the actions of a director in a governance situation. So if you make a mistake, and this usually came up in the context of bankers and savings and loans, but in any organization, if a director or several directors or the entire board vote to do something on behalf of the corporation, it turns out to be a bad deal, a bad idea. The business loses money, something goes wrong. Does the fact that you made that decision necessarily impose some sort of financial liability on the directors? And the answer to that is no. We always want to look to see if the directors who made the decision were acting in good faith, if they had not breached a fiduciary duty, if they had not engaged in self-dealing or doing something for their own benefit. So you have to really almost intentionally do something wrongful that causes damage to the corporation for you to be financially liable. Now, so you can see how that all ties into what we've been talking about, and certainly that Edmund talked about at the beginning here, is that it's a serious proposition for all of us. So those of you who are on the call who are on the LBF board, when we start talking about grant money, for example, and how much money passes through kind of as an agent of the Supreme Court, passes through on the IOLTA side. When you start making decisions about awarding grants, there's some times when maybe the money doesn't get used properly downstream, right? Does that make everybody on the board of the foundation liable for the misuse of that money? And the answer would be no. As long as all of the things we're talking about here, the board members' votes are done in good faith, and they're all disinterested. Unless there's some knowing misconduct, ordinarily we don't impose liability on a director, but it's important to understand that there is a consequence for bad conduct here. And that's the point of talking about a director's liability. Now, in addition to liability for acts that a director takes, sometimes the corporation itself may be liable to somebody else, an employee or some third person who sues the business or the organization and alleges that one or more directors did something wrong. We see this sometimes in employee situations with policy violations. Can the corporation do something to help protect that director from any financial liability? And the answer generally is yes. Edmund, you want to talk a little bit about how we do that?
Well, insurance would be one area.
That's a good way to do it, right? Just like you would insure your home, right?
That would absolutely go into it. What we're talking about here is indemnification and insurance.
You can go to the next slide, Renee, if you would.
Yeah, thank you.
There you go.
So indemnification is provided in a couple of ways. Your corporate, well, there is an indemnification provision in state law, and what Skip and I typically are referring to is Louisiana state law, but in most other states there is some indemnifying language that is applicable to those organizations that have not specifically provided for it in their bylaws. And in most instances, in fact, I can't tell you of an Inc. or an LLC that I have established in the last 30 years that hasn't had indemnification language in it. What does that mean? That means that if you are acting in good faith, well, let's go through the second point. As I mentioned earlier, it's insurance. Insurance is another way to protect the directors and officers, and it's not surprisingly called Directors and Officers Insurance Coverage. D&O is what you hear. This is another important, I will call it, piece of paper that Skip and I always suggest you ask for when approached about serving on a board of directors. You want to look at the bylaws. You want to make sure that the tax returns have been filed. You want to make sure that there's a fairly recent audit, because it's not necessary or not required that an audit be conducted every year, but you want to see the most recent audit to get an idea of the financial situation. You want to know that the 990 has been filed, and you want to see that there is sufficient and appropriate insurance in place, particularly with a little bit of self-interest, that there is directors and officers coverage. And we'll talk a little bit. Yeah, Skip, go ahead.
Yeah, I was going to say, this is a very simple thing to do, at least in terms of the corporation providing the protection to its directors. And you do that in the organizational documents. And we've had some discussions over time, depending on the financial size of an organization, whether the cost of directors and officers insurance is justified. And a lot of that is simply going to be a question of evaluating risk. And one of the things that you as a director should be involved in is evaluating risk just in general about and how much insurance and what kind of insurance you would purchase. So while I agree with Edmund, directors and officers insurance is always a good thing, it may not always be a practical thing. Does that mean you should decline to serve on the board? The answer to that is no. If you do everything else that you're supposed to do, this should not be an issue. But if you want a level of protection, then you ought to make sure that the bylaws or the articles provide that the corporation would indemnify you in the event that, irrespective of whether a lawsuit would be meritorious, be well-founded, you could be protected and defended by the corporation on whose behalf you've been acting. So this is not this is something that sometimes will frighten people, just about the risk of having the prospect of being sued. In reality, the risk is probably pretty low for most of the organizations that we're dealing with right now, but it is still something you ought to be aware of. And frankly, there's just no harm in having this protection built into your organizational documents. And we'll talk a little bit more in a minute about those documents and what you ought to be looking for. But as we're talking about duties and breaches of duty and consequences of breaches of duty, this notion of insurance and protection it kind of fits very nicely in that discussion. And it is also a topic that you ought to be aware of, and you ought to be satisfied that in return for your service, and usually service without compensation, right? At least you get this amount of protection for your efforts.
Yeah, as you saw there, Renee, would you go back one just real quick? Yeah, the statute that indicated provides that you are eligible for indemnification if you're acting in good faith in the best interest of the corporation. And again, this goes back to conflicts of interest. You are part of a majority vote of disinterested directors voting in favor of indemnity, meaning it may be one director who's being indemnified, not the entire panel or not the entire board. And so that particular director, let's say you in this case, you can't vote in favor of indemnity, but your comrades, your colleagues on the board certainly can. And I know we're going to get into it, but Skip alluded to it, so I'm going to drop it in here and then we'll pick it up when we get to the slide. But acting in good faith also means you're, as Skip said, relying on the staff, relying on your outside attorneys, relying on your outside accountants or financial advisors. You are, as a director, entitled to rely on professional advice and opinions in making your decisions. And then we, as professionals, will take the Bar Foundation hat off for a second and act like lawyers and say, and then it's our responsibility to make sure that advice was sound. And if it's not, then we're talking to our insurance coverages about ways to address what may be a harm in that case. But certainly there are circumstances where situations arise or issues arise that a director may have no familiarity with whatsoever. It is outside of their purview. It is outside of their realm of experience. And in that case, it is certainly okay and encouraged to rely upon professional advice.
No doubt. This might be a good place to just stop and see if anybody has any questions about what we've covered so far before we go into the next section. Anybody out there? David Verlander, you don't have a question about this?
Skip, I've been through this, I think 4 times on the Bar Foundation board, and this is familiar to me. So I actually appreciate the refresher, but I don't have a question.
Can I ask you a question then? So when you were asked to sit on the Bar Foundation board, were these some of the things that you thought about and asked about? I know you've been involved in lots of other organizations too.
Yeah, I was, and Mike Street was very helpful in getting me the foundational documents that I needed to look at to feel comfortable. And then the Bar Foundation has a great training session for new board members at the first meeting after they're elected. So it was a well set up process.
And what you just said about that seems to me is a real important thing to offer your incoming board members, right? I mean, even if it's one board member of a board of 5, you sit down with that one board member and go through something like this to orient the board member to the organization and what it does and how it works. And here's the papers you need to look at. Here's what's expected of you. We'll talk a little bit more about recruiting directors and that sort of thing, but this is kind of the basis for everything that else we're going to talk about here. And understanding your duties and responsibilities is really important. And look, frankly, if you're uncomfortable about what you're told, then the best thing for you to do is to say, how else can I serve? Maybe this isn't for me, right? That would be unfortunate for the organization if you've been recruited. But if you're uncomfortable with these responsibilities, it's better to find another way to serve the organization where you're maybe not taking these obligations on than to fret over this, because that's not our intention here. It's not to scare anybody. It's not to persuade you to say I resign. It is just to make sure that we're fair in expressing to everybody what obligations you undertake when you become a director. Like I said, it's if you want to bring the donuts, that's fine. Everybody else will appreciate that, but it's not just about bringing the donuts. So we okay? No questions? Well, Edmund, either that means we were going to lose a bunch of prospective directors, or we're doing a pretty good job so far, right?
Well, or the third option is they're all asleep, Skip. So
Okay, well, you'll never know
let's
that,
be
right? So,
plowing through.
yeah. So, well, why don't we go on and talk a little more specifically now about uh, responsibilities of the board and some of this stuff we've already touched on, but if you start thinking about uh, in the context of the duties of a board member, we're going to bear down a little bit more detail here and talk about some specifics that will help you, I hope, understand your obligations in context of the nature and function of the board you've been asked to serve on. So, mission, policy, and finance. And I'm gonna punt the finance part to Edmund, so because I know those of you know me would understand that I don't know much about that. And so I would rely on, and this is a place where I would rely very heavily on staff. And as Edmund mentioned, our outside accountants and the people who are advising us about finance, not to be uninformed and not to be totally ignorant, but understanding the larger scale that the organization has, the more difficult or complicated the financials can be, and the more advice you might need. I'm going to let Edmund talk about that, but so let me speak a minute about mission and governing documents and what you want to look at and what you want to do. Sort of seems to me that everybody that we're talking to today with respect to their individual organizations has some familiarity with what that organization does. Rarely do boards invite to be directors people who are totally unfamiliar with the organization and totally uneducated and purely outsiders. Every now and then you'll see that in a larger board, maybe where you're looking for somebody with a special skill set. But generally speaking, for our grantees, the people who are on the boards or either have been involved in the work of the organization or clients of the organization or have some connectivity with the organization. So they have kind of an understanding about what it does. But in our governance documents, our articles of incorporation or our articles of organization, if we're a limited liability company, and in our bylaws, we almost always see a statement of what the mission or purpose of the organization is. It's a question of law. We tell the state, we're forming this entity to do this. That can be very broad, but generally speaking, we talk about it in a little bit more specifics, particularly when it's a not-for-profit organization. And if the mission is not spelled out in detail in your organizational documents, my guess is that somewhere else within the organization, as a result of some strategic planning exercise, there's going to be a statement of what the mission of the organization is. I mean, when we look at, for example, when your organization submits a grant application to the grants committee, we want to know what you're going to do with that money, right? So you're telling us a little bit about how you're going to use the money to carry out your mission. So knowing and understanding the mission of the organization is vital. You cannot be making governance decisions in furtherance of the mission if you don't know and understand what the mission is. So it is certainly fair game to look at and ask for mission statements, the articles of incorporation or organization. And then one of my favorites, and one that probably gets the requisite amount of attention, is bylaws. So you see here what we say is the articles tell us what we can do legally and sometimes what we cannot do legally. But the bylaws really tell us how we're doing it. How are we carrying out the business of the organization? And frankly, if you're not following your bylaws, you need to do one of two things. You either need to adjust your conduct to what the bylaws say, or you need to change your bylaws, right? And over time, organizations grow, they change, they get more sophisticated, so it's not a bad idea to review your bylaws periodically. For example, the Bar Foundation. So we've got a fairly robust board. We rewrote the bylaws several years ago, but we have a governance committee that looks at the bylaws every 3 years, just to make sure the bylaws are telling us how, or matching the way we're doing business, telling us how many directors we can have, what their terms are, what the officers are. And we changed some of that not long ago because we thought the organization needed to adapt to some needs that we had in terms of management and governance. So the bylaws are far more living documents than maybe the articles are. You typically don't fool with them very often. The bylaws are telling us how the organization has decided it will organize and manage itself. And so if I were going to ask for anything out of this list of documents here, it would be show me the bylaws. And I am going to tell you that I'm going to insist that we follow the bylaws. Want to stay out of trouble, that's a really good way to do it.
Skip, we had a question in the chat that popped up with respect to bylaws, and it says, whose responsibility is it to do that in the role of the executive director? Question mark. So I think they're asking, one, who's putting it together, two, who's reviewing it, and where does the ED come in to play?
So here's a smart alecky kind of answer. You got a lawyer on your board, that's who you go get and say, rewrite the bylaws, right? But it usually is a function of the board of directors to adopt the bylaws. And you can do this every year if you want to, if you need to change them. Do you have management input into this? Yes. But to me, this is a function of the board describing for everyone how it has decided to conduct its business. And so it is a board function, and typically it's not something that the membership of the organization needs to adopt. It's something that the board itself generates, revises, adopts, and then implements.
Skip, we here at the Baton Rouge Area Foundation went through an overall governance review that was fairly extensive. I mean, and this is all in connection with the leadership transition over the last couple of years, but we looked at our articles, our bylaws, our committee charters, and even now into policies and procedures, and have made, I wouldn't say extensive changes, but have made changes to each and every one of those documents in the last 18 months. And part of that process, as Skip just described, was driven by board-appointed committees. But those board-appointed committees also included staff members here, because as we all know, the bylaws say, how are you supposed to do it? Well, the fact of the matter is something may change. It could be a technology that changes the way that staff is able to do something, and it is much more efficient than the way that it was written down 5 years ago. And so while we may have migrated to a new system, we didn't necessarily change what needed to be changed in the bylaws. Let's catch that up, right? I always remind folks, bylaws are the rules, and the rules can be changed to meet the standard of today, right? It could, like I said, it could be technology, it could be the passage of time, it could be obsolescence on the part of something that just simply isn't done anymore. So it is important. It is, as Skip said, it should be board driven, but it is important to get staff input, because the first question as a director that I always like to ask is, how are you doing it? Let's forget what the bylaws say for a second, and we're going to, if there's a problem, we'll address that. But if not, tell us how you're doing it, and is that the best way to do it? And if it is, then let's write it down.
Yeah, I couldn't agree with you more. I mean, either follow the bylaws or figure out what you're doing and change the bylaws. Those ought to always be in sync, right?
Exactly.
And I just think of that as just your handbook, the handbook about, because it'll tell you things about who your officers are, when they're elected, how many board members you're going to have, how they're selected, what their terms are. You know, and as I mentioned with the Bar Foundation, we actually remissioned some of the officers. So because we saw that there was a need to have, for example, the vice president of the foundation really didn't have a lot of specific responsibilities except wait to become president. Well, we had some people that were overburdened a little bit, like the treasurer, right? So the treasurer had all this other stuff to do, and then Renee was trying to keep them in line with respect to grants. So we just said, how about, if I think I got this right, let's give the grants process to the vice president. It's worked out really well. So we changed the bylaws to do that. We changed the function, we changed the responsibility, we changed the bylaws. So how's the IRS play into this, Edmund? I always get a little nervous when we start talking about the government. So you want to comment about this?
Sure. Well, the first thing, as Skip said, when you filed your articles of incorporation, you were telling the state what it is that you want to do, and what and the state is in some ways responding by approving your filing by saying this is what you can do. The Form 1023, which is the application for exemption to essentially become a tax exempt public charity or private foundation in some cases, is you are telling essentially the same thing to the IRS. This is what we are going to do. And we would like for you, IRS, to grant us tax exempt status under 501c3 of the Internal Revenue Code. Well, what does all that mean? I think that Form 1023 is the greatest storytelling tool that is available to you outside of your annual Form 990. And that is because it is the original intention of the organization and the founders, essentially, as to what this was supposed to be. Now, as things have evolved over time, what you may find is your Form 1023 has the original name of the organization. Well, times have changed, and your organization has amended its articles to change its name a couple of times, so you don't even match up to the 1023 anymore. Or the mission may have slightly changed over time, and you've done what you're supposed to do via the Form 990 to tell the IRS that the mission has changed somewhat. So it's a historical tool to say this is where we started. Much like the articles of incorporation, they may evolve over time. Much like the bylaws, they may be amended over time. But it does tell you what the original intent of the organizers was when establishing this group. It also gives you some insight into the changes, the growth or not of the organization since its inception. So if you looked at a Form 1023, there was an opportunity there for the organizers to tell the IRS, well, we think that we're going to do this, and we think that we're going to bring in this much money, and we think that we're going to make this much in charitable grants. How close were they? It's interesting. It's not important. It's certainly not important when you get decades down the road, but it's always interesting to see. It gives you great insight into where you came from.
So any questions right here about the organizational documents for the benefit of the board, or what needs to be amended, when it needs to be amended? these are the kinds of things you need to have at least a working knowledge of, because as we said, it tells you how you are going to operate.
Skip,
Okay.
I'm gonna, since he's still up on our screen, I'm gonna pick on Dave Verlander again a little bit. Dave, you've been going through this with the establishment of a new organization in Northeast Louisiana. Can you tell us a little bit about the process, because you've just done it?
Well, we're in the midst of just doing it. We have not actually been operating a full year yet. We're trying to get a pro bono organization going up here with a local regional bar foundation. We had the blessing of having the State Bar Foundation staff give us a tremendous amount of support and foundation, and a couple of the other regional bar foundations, particularly Shreveport, provided us with a lot of the base that we needed. And we have the good fortune to have several directors who have been on this type of board in the past, some of them on the Bar Foundation board, as well as me being on that. So we kind of started on the shoulders of other people, and that helped a lot. We didn't have to do a lot of ground level educating directors. We've just had a couple of new directors come on the board, and we are, and they've been attending these sessions. I saw that one is signed, at least one is signed in this morning. So we'll be working to bring them up to speed on these documents and policies and procedures. But again, we've got a lot of sharp people who've done this before, and that's been a huge benefit.
It always is. Thanks for sharing that with us.
I'll tell you also, Edmund, just recently, just to show you that the best of organizations sometimes forget to play catch up with themselves. We just redid the bylaws for the Supreme Court Historical Society. So you'd have thought of any organization that was on top of this would have been something dealing with the Supreme Court. And it was just very much like any other nonprofit organization. You're a bunch of volunteers, you're focused on doing the mission, but you kind of get a little bit behind in the governance process to make sure that you, current and future members, know and understand how this is supposed to be done. So we spent some time doing that. And if you don't think there was some tension involved, it was one of those things you had to send to the Supreme Court for review. So it was a little bit like getting the principal grading your paper. But the point there is that it is it's common that we don't spend as much time as we should with this. So the point here is, if you're not familiar with the bylaws, you should be. And if the bylaws aren't accurately depicting how your organization conducts its business, then either change the way you're doing business or change your bylaws. Very kind of a simple, succinct summary. I see, and I happen to know this person who's asking this question. So, hey, Kathy, how are you? Kathy is actually my sister-in-law. So is that a disclosure I need to make here? I'm not sure. Hi, Kathy. There's no set time to do it. The Bar Foundation Governance Committee does it, I think, 3 years, but it's got kind of a rotating schedule. It does, for example, it does insurance every year. It does certain policies in year 2. It does bylaws and other things in year 3. I would say if you have a market change in leadership, sometimes the way the boss wants to do things, or if you think you need to make a governance change, like we need some more directors, we need to recruit some people who are talented in these areas, and we don't have adequate space in our current board structure to do that, then you should modify your bylaws. Or, some bylaws have term limits. Is that a good thing for your organization or not? You decide that as a matter of policy. But if you have term limits in your bylaws, then you have term limits. And if you don't want to have term limits, then amend your bylaws to get rid of them. So it really is a kind of an as needed basis, if that helps you any. But look, you wanted to have a policy among the board, something we'll talk about next is policies. So how often do you review all of your policies? How often do you review we're going to ask you when you apply for a grant, if you have some policies in the application. You have a whistleblower policy, I want to see it. How often do you review that? How often do you have someone like your legal counsel review it to make sure it is correct and adequate? Do you have some personnel policies? Do you have a compensation policy? Do you have a conflict of interest policy? It's not a bad idea to have an annual review of those things, and you can throw the bylaws in at the same time. So hope that helps you some.
That's good.
So any other questions? Okay, well, let's talk about policies. Edmund, policies are good things as long as they're accurate, well-written, legal, and you follow them, correct?
That's right. That's exactly right. And I think to the point, Skip, I'll jump to this and then we come back, but policies like bylaws should be on some type of schedule. They should at least be looked at on a 3-year or 5-year basis. And that gives directors some comfort, even new directors, if there is some type of governance or policy review schedule that sets out when these things are going to be looked at with a very critical eye, as opposed to just utilized as the tools that they are throughout the course of the year, then it gives a new director some comfort to hear that there was a bylaw overhaul and review and revision that was done in 2022. Okay, well then these folks have looked at it pretty recently, so hopefully it's fairly accurate with respect to what is going on. It's the same with policies. I think there's a couple of things here that make policies sound like they are mandatory. They are not mandatory. They are helpful. They are beneficial, but they're not mandatory. But it allows you to develop the goals and objectives relative to the mission. So you've got the overarching mission statement, and then you got to figure out how it is you're going to carry that out. How are you going to implement the work that needs to be done in order to achieve the mission? Well, the first thing that you do is you hire the executive director or president and CEO to carry out that mission. That is their job. The mission standard is passed on to that chief executive in order to set the vision and carry it out. So I'll back up and say, so what's the board's job? The board's job is to watch the executive director. The board's job is to make certain that all of those things are happening. The board's job in most instances is not to run the organization. It is to manage and supervise the chief executive, whomever that might be. And what does that entail? Well, that entails certainly evaluating on a regular basis. I would suggest annually, but there's no director should be out of communication or out of contact with their leadership, with their board of directors, certainly not with their board chair or executive committee for any significant length of time. You have to compensate that director. Well, how do you determine what's a fair and appropriate compensation? Well, one of the things that you are asked on an annual basis in your Form 990, which is your tax return, is did you consult any surveys? Did you hire a compensation consultant to give you advice as to what appropriate amount of compensation might be? Or do you have a committee? And it can be one or two or many of these factors that are listed by the IRS to come up with fair compensation. It's market value, it's appropriate for the mission, it's appropriate for the size of the organization. It is not directly tied to the income and outflows of the organization, but it can be a factor when looking at the overall operations. If we're paying an executive director an outsized salary for the size of the organization, then that's something that we might want to look at. Going back to surveys, going back to consultants. And when I say surveys, surveys have become so much easier nowadays than they used to be. And in a lot of instances, folks would pay for a survey, but with the ascendance of technology, Form 990s are publicly available and easily accessible online. So in a lot of instances, my own organization included, what we've done is on an annual basis, we gather the information from our colleague foundations around the country. We're looking at similar size. We're looking at the tenure of the CEO. We're looking at a number of factors that would make, say, the Denver Community Foundation look a lot like the Baton Rouge Area Foundation, or the San Diego Foundation and the Baton Rouge Area Foundation. Similar size, similar assets, similar grants. The CEOs are tenured about the same amount of time. So we can use that information as a comparable to determine if we are compensating our folks fairly and appropriately.
You know, that the notion of compensation and fair compensation is important for governance, of course, but as Edmund mentioned, for your nonprofit status, and that's why you want to spend a little time there. You want to make sure that while you're compensating your staff fairly and appropriately, if you can run into trouble if this looks like an out of line compensation package. It kind of belies the notion of the purpose of a nonprofit organization. So this may not be as significant an issue for you depending on the size of your organization, but I do think that we go through this process. We did go through this process with the Bar Foundation and surveys and understanding compensation, and we did that review annually. And I also wholeheartedly agree with Edmund's statement about the board's job is not to manage the organization. The board's job is to govern the organization, and they are very different things. If you're going to manage the organization yourself, you probably don't need to hire a staff. Just if that's your view of the world, that your board needs to be involved in every decision that gets made between 8 and 5 Monday through Friday, then you're wasting money to hire a staff. Just do it yourself. Instead, and that's kind of where these policies come in from my perspective, the board's mission job is to establish policies and objectives and then oversee the staff as they carry out that guidance. Some of the policies that you see here, Renee, you go to the next slide if you would, help do this for everybody.
Yeah.
So compensation aside for just a moment, when we talk about conflicts of interest, we're also talking about some of the obligations of a fiduciary that we talked about in the first section here. Do you have a conflict of interest policy? What is your policy about disclosure of conflicts? If you just happen to have a conflict of interest, a topic comes up, you want to buy a service, and you as a board member have a family member who has an ownership interest in one of the companies you're considering. Maybe that's a decision that gives rise to a conflict of interest. It's not that you're assumed to have a financial interest or doing something wrong. It is just to avoid even the appearance that there would be some impropriety there. How do you define those conflicts of interest? At what point do you want your directors to disclose them? And then will you require your directors to recuse themselves from voting on a matter where there is a conflict of interest? So for the Bar Foundation, for example, we do this at every meeting, every board meeting. You look at the agenda. If something comes up where you maybe have a conflict of interest because the board, for example, is going to vote on a grant to David Verlander's new pro bono project, and David is on the board of the new pro bono project, we would expect David to recuse himself from voting on that grant request, not because he's going to get anything out of it personally, but because he's got an interest in the success of the grantee. So those kinds of things are really important so that your board members have an understanding of what the expectation is of avoiding a conflict. And if you don't have a conflict of interest policy and you want to see what one looks like, shoot Renee a note, and I'm sure the Bar Foundation would share its policy with you so you could adopt it. And there are any number of other policies. Now you look at your grant application, and they ask for those of us on the grants committee, when we come to see you or we come to talk to you about your grant application, some of the things we're going to ask you about are these policies. Do you have policies that govern so that your employees and your board all know what your expectations are? Do you have personnel policy? You know, and it may include stuff like leave and benefits. It may have stuff like evaluations in it, training. Do you have a whistleblower policy? This is really kind of an important thing for us. What we want to do here is encourage the organization to encourage its staff and governance folks to call out something that violates a policy or that's wrong without fear of retaliation. We have some state laws that govern this. It's an important kind of policy. Can you have other policies? Certainly, you can have a policy statement that deals with almost any topic of importance to the organization. And I do agree that it's an important thing to review them annually because they do tend to get a little bit out of date, a little bit thread worn over time. So think about, we're not trying to create a bureaucratic nightmare for you here, but the things that are really important: personnel, conflicts, whistleblower, maybe something else. And
Skip, I was going to say that as I said, they're not required, but the IRS asked the question on the Form 990, do you have a conflicts of interest policy? Do you have a whistleblower policy? Do you have a document destruction and retention policy? And of all things, do you have a joint venture policy? Those are the specific policies that are requested. And folks, I always counsel the organizations that I work with to say, if the IRS asks you a yes or no question, they would like to see a yes. So as Skip said, implementing a policy such as a joint venture policy, it is very rare that you would enter into that type of arrangement, but it is of no consequence to have the policy, to understand that it's there, and to know that you have the ability to check the yes box on the 990. The others, I would say, are extremely important. Conflicts of interest and the whistleblower, as Skip mentioned, are two that are almost unavoidable. And I think any accounting advice, and in some cases legal advice, would tell you that a document destruction policy is the way to go, particularly in the fields that you are all working in, where you are in some instances gathering sensitive information about your grantees and the folks that you benefit. You don't want to keep that information forever if you don't have to. That's just good. That's good sound advice. And also, look, the physical nature of storing files versus destroying when appropriate. There's a cost there. There's a cost associated there. So it's good fiscal management as well to maintain that.
Yeah. And some of those you might want to ask your accountant, if you have an outside accountant, how long do you think we ought to keep these financial records? And the nature of the records, maybe you want to, these things, they're really not rocket science. Again, this is one of those areas where I think the Bar Foundation would be happy to share with you policies, and you might not necessarily implement them as written, because some of them won't apply to you in all respects, but they're good outlines. They've been vetted. As I mentioned, they get reviewed pretty often. And like with the bylaws, once your board adopts the policy, then you need to comply with it. You need to comply with your policies. So an important function, an important governance function, and an important guide to management. So if you might want to have a conversation at the board level, look at the 990 and see. I didn't know they asked about joint ventures, but it is better to say yes. And as long as that's a truthful answer, I agree, than to try to say no and explain your answer. Remember those days in school, right? Explain your answer is always the challenge. So pay attention to that. So when you're looking from a governance perspective at your organizational documents, your articles and bylaws, Think about the policies, the topics that need to be addressed by the board in a policy statement of some kind, either because it's a good idea for your organization or somebody else has asked you or will ask you for it. And then if you need some assistance, just please reach out. I'm sure that the governance committee and the leadership of the foundation would be happy to help you, or maybe point you to a brother or sister organization within the fold who might be similarly situated. So, so questions about that part of the presentation?
Skip, we've got three questions that came over the chat, and they are
Okay.
relevant to the discussions that we've started. The first, any thoughts, pros and cons on term limits? How long is a good length for a term? And what is the ED's role? And I'm assuming in determining what those term limits are. I know you and I both have a lot of thoughts on this, but you go ahead.
I do have some thoughts. I think term limits can be really good if you have an organization that has a hard time asking people to leave. So in your experience, you're always going to find, or you will sometimes find, I don't want to overstate this case, you will sometimes find that you pick somebody, you invite them to be a director, and it just doesn't work out. They just don't contribute to the level that you need for them to do. And I think all of us can agree that there's work to be done here. Being a good director, how do you get rid of them? So we've had conversations with some grantee organizations about how can you encourage a director to resign? Can we tell them that they're fired? You may want to put something in your bylaws that is sort of a term limit. If you miss 3 consecutive meetings, you're out. Something like that helps you control non-performing directors. On the other hand, the other side of this is that, an arbitrary term limit can sometimes deprive you of some very talented people who want to continue to serve. And some of this depends just on the philosophy of the organization. So I can tell you I'm on the board of an organization right now that has term limits. And I am in my last year of my last term. And I am disappointed that I won't get to continue. Now I've overcome this and realized that I can go find something else to do, and that there are plenty of other people out there that will benefit the organization. So you got to think of it from the director's standpoint as well. You can become a stale organization if the entirety of your board has perpetual appointments. It's going to happen. People get tired. They lose their enthusiasm at some point. They don't look at matters critically enough. So I think probably on balance, term limits for directors is a good idea. How many terms and how do you do this? Seen bylaws where you would say the terms of a director are going to be 2 years, 3 years, and you can be reappointed once or twice. So if it's 2 years, you're talking about a 6-year total term of office. And then some bylaws will say, and then look, you could step aside for a year, and then you're eligible after a year of absence to be reelected to the board, and then you get another 6-year term. And that 1 year really is kind of some downtime. And if you still have the same interest in the organization after a year and you want to be invited back, then fine, we'll set you up for another potentially 6-year term. Some others, like my example, is just absolute. There are no extensions. You do your 3-3-year terms, you do your 9 years, and thank you very much. You can still stay engaged with us, but not as a board member. So I think it depends a lot on the nature and size of your organization. I think it's in the Bar Foundation's case, we've had people take a break and come back. We've had people take a break from the board, come back, and ultimately get in line for an officer position. I don't guess there's any real magic to it, except there is to acknowledge that there is some goodness, at least in having a mechanism by which you can replace a non-performing director.
Yeah, I agree. I agree with Skip's points. There is a point, and I don't know where that point falls, and it sometimes depends upon the organization, and it sometimes depends upon the person themselves. But there is a staleness point that arises, and you will see. I think most organizations have some variation of, as Skip said, 2 or 3-year terms. That means you're giving that director and you're giving that organization an opportunity to politely part ways every 3 years. But they still have this opportunity to serve for 6 or 9 years. One area where you do see where it does become tiresome is an organization, and I know that we all know several, that will almost require some board service before you enter into what they call an officer track, and it will lead you to ultimately the presidency or the chairmanship or a past chairmanship, and then you're off the board. And and in very, very unique circumstances, that can be 9, 10, 12 years. And I'll share this anecdote with you that we had a director here at the foundation. We have 2 3-year terms, and your service can be extended by falling into line to be the vice chair and the chair of our board. So it could potentially serve 8 to 10 years if you end up as the board chair. We had a particular director who was invited to fill a partial term that had, it was like 2.5 years of the 3 years due to an unfortunate passing of a director. So served for 2.5 years in a partial term. Well, under our bylaws, a partial term does not count. So this director was then elected to his first full term. He was elected to a second full term. He was put into the leadership track. He served 2 years as vice chair. He served 2 years as chair. He is going to serve 2 years as the past chair. COVID comes along, and we extend the term of our board chair an additional year. So that extended the term of our past chair an additional year. He ended up serving 14 years on the Baton Rouge Area Foundation board, which is unheard of. Yeah. And I got to tell you, he's a good friend of mine, and he was tired at the end of that. He was a little bit tired of the foundation. And so, we've taken steps to hopefully avoid that in the future. But that's a unique circumstance that I share with you only to show you that even with 2 3-year terms, we had a very long standing board member.
David, you're right. I mean, you got to consider the market too. I mean, where if you have an organization that perhaps requires clients to be on your board, that's a factor you need to consider. Or where are you geographically in the sense of being able to recruit qualified directors who have an interest in your organization? That's another factor. So I don't think there's a one size fits all. I think I had to pick a model of the ones that I've seen. The one I thought that was practical was an organization that had like 2 3-year terms and then a year break, and then you could get 2 3-year terms, and then that was it.
I agree with that. That's the most common. You see, sometimes you'll see 5-year, like 2 5-year terms, and that's it. And that 5 years, is a good breaking point as well. But I would add, with respect to qualifications, I also think that it depends, again, as I've said, and I think Skip has as well, the type of organization that you are. And if you're an organization that is strongly dependent upon the public-facing board of directors to be out advocating your message, raising money, showing great support for you, there is certainly benefit to long-term directors. There is also benefit to new blood. And so you have to balance the issue of, age, experience, and interest in the organization with spreading out the exposure of your board to, or your organization via your board members to new subsets of the community. And that could be age, that could be profession, that could be, geographic location.
Right.
But thinking about those factors and being able to refresh your board, which I think keeps your organization viable.
Yeah. Somebody that's interested in your mission. I do think though, no matter what you pick for term limits, your bylaws ought to provide for the disqualification.
Yeah.
It's a polite word, of a director who is not participating, right? So depending on how often you meet, if your board meets monthly, well, you might want to think of that in terms of missing so many consecutive meetings. If your board meets quarterly and you say you want them, if they've got to miss 3 meetings, well, they've almost blown through a year without participating. And so you don't really have a director there, do you? You just don't. And we had some questions when we first started doing this and going around talking to organizations. Well, Miss So-and-so's been on the board, Mr. So-and-so's been on the board for a long time, but they're just not coming to the meetings anymore. And we're kind of stuck with them. Well, you're not really stuck with them. You need to provide in your bylaws for some criteria for declaring that seat vacant, as it were, right? Other than death or term limits or resignation. And I would recommend that to you. Just so you could, you got plenty of stuff to do. You need a full team.
Yeah.
And you don't need to have a de facto vacancy on your board just because somebody likes the idea of having their affiliation with you on their resume, but decided to quit coming to your meetings and helping you. So, Edmund, we got about 30 minutes left, and I know we want to talk about the money piece here.
We do.
Before we punch out, were there some other questions on this?
There were, and these actually kind of roll into the money piece. So this might be a great entree. So the next question was, should the board be involved in hiring and firing of management staff, not the executive director? I'll jump in first and say, my colleagues on the boards that I serve on are tired of hearing me say this, but as a director, and even as an executive committee member, my job is not to manage the employees. My job is to govern, right? And that means supervising, observing, and counseling the executive director or the president. So when we say, should they be involved, I think there's degrees of that, right? If we're hiring a CFO or finance person, do you want some other eyes and ears in an interview? Of course, and that's certainly appropriate. I think utilizing your volunteers as a screen for that type of engagement is certainly appropriate. In many instances, it's your board that has more experience in hiring and firing than it is the organizational staff. So I'd certainly agree on the hiring end that it's appropriate for directors to be in the room, engaged in the process. In the firing process, I do think it's a little bit different. I don't think directors should be firing staff. I think that is the job of the executive director. But I do think that there is a certain level of counseling and advice that goes into the process. Again, you as a director may engage and may hire and may employ a significant number of people. So this is something that you're very familiar with and almost comfortable with. So it is certainly appropriate to give advice and counsel to the director as you go through this process, to look at how is it done? Is there an exit interview? Is there who's in the room? And it goes to the size of the organization's staff. That may not always be practical. Could it be that a board chair may want to participate in that process, or a treasurer if it's a finance person? there's nothing wrong with it. It's just remembering the roles of each of the players as you go through the process. Yep.
Yeah, I want to agree with you there too. I just went through this with on this board about that I'm about to finish up on. We had to hire a CEO, and we did that, and we hired a very good CEO. And then we had some vacancies at the level direct reports to the CEO, and the CEO engaged some directors to participate in interviews just for feedback. But at the end of the day, we all made it really clear that he was hiring his team, that we'd tell him what we thought, but at the end of the day, it was going to be his decision. And that helps do a number of things. Number one, it makes it clear to whoever gets hired that they work for the CEO. They don't work for the individual board members. And I'm going to come back to a point about that in just a moment.
Great point.
And I think on the termination side, the thing that warrants the involvement of some of the directors, maybe it's just the executive committee if you have one, just to make sure we do this the right way, because employment terminations is a fertile field for litigation these days. And if you do it according to your bylaws and there's all this due process, the chances of you being able to part ways in a non-litigation context get really enhanced, more so than if the CEO just walks in and points his finger in someone's face and says, "You're fired, clean out your desk." Just that doesn't usually end well. A comment about board members and relationships with management. Two things. The CEO or whoever reports to the board as management, the executive director, they work for the board. They don't work for the chairman of the board. They don't work for individual board members. And for me, while it's appropriate for an individual board member to make a request of information, for example, or to meet with the CEO, it's never appropriate for an individual board member to instruct the CEO to do something, because there's no one director controls that, not even the chair. The chair is going to be the point of contact and maybe the coordinator. And some CEOs look at the board chair as their boss, but that's just not right. I mean, you work for the board as a group, as a collective. But that said, I do think, depending on the skill set for the individual directors, the hiring, firing process, it's a good thing to try to involve board members in that, although for different reasons. So why don't we, do we have another one?
Last one.
Okay.
And this is straight up financial. How about salaries of management staff, say the executive team? How's that determined?
Well, you already talked a little bit about the executive director. Then what do you do? Do you try to, if you only have two people in the office, that's not so hard. But what happens if you have a fairly robust staff, and do you set up a salary schedule, or I mean, and does the board have to approve that? How does that work?
Well, I think let's talk about a sizable staff, because I think that's where the questions really come up. So again, the 990 information that I talked about is not just applicable to CEOs and executive directors. In some organizations, albeit larger organizations, you will find salary information for, say, a vice president of grant making, or a vice president of finance, or CFO, or any of those roles. I think that's a first look source. Now, you may say those salaries are outsized for our organization. We don't compare. It's apples to oranges. Okay. So look at the job responsibilities of that particular person. So what does a director of finance make in your community? What does a director of finance make roughly? We're just guessing here. It's in some cases. In other similarly situated organizations around the state, or around, maybe regional, around the country. What size city are they working in compared to where you are located? All of those things are factors in determining what's a reasonable compensation. Again, can directors be of assistance there? Yes, they can. They absolutely can, because they can give you, let's go back to that prudent person reasonableness rule. They can give you the smell test on a salary to say, $95,000 for a receptionist might be a little bit out of line. Let's look at what receptionists make in Baton Rouge, Louisiana, with no experience, or working for a nonprofit organization that looks somewhat like yours, and does need that role. And I just choose a receptionist because I think everybody knows what that is. That's one way to look at it. Certainly, again, I'm back to, yes, the board should be aware. To Skip's point, does that mean that we're setting up salary schedules? Well, you could. I mean, in sophisticated organizations, there ought to be a range, and I think that that's a good expectation for your board, because they know kind of what your budgeting guidelines will be as an employee moves forward. They also know that there is the possibility that, yeah, at some point this position will cap out. And does that mean that you can't give cost of living or things like that? No, it doesn't. But it's never going to be more than what it is, because within this range, within this person's experience, with the time that they've spent with the organization, we've just reached the max that we can pay for this particular job.
Yeah.
Every job, unfortunately, doesn't lead to the CEO's office. There are some that do stop at some point. We have that in our own organization, and I see it in other organizations. So it's good to be aware of that. But I don't think that should limit the engagement of the board in assisting with setting the salaries, particularly in a new organization. As we talked about, or in that 5-year cycle of review, is this something that should be considered? Yes, it should. Put it on the list, and then have a group of volunteer directors get together, talk about it, take a look, give you either a blessing or give you some advice as to where to go, which direction to go in. Skip?
I always thought that where the board influenced this most directly was just in the budgeting process. So the CEO and maybe in conjunction with a finance committee, if you're large enough to have one, develops a budget that's pretty granular, and you look at salaries and benefits, and that's probably, other than programmatics, that's going to be your biggest expense. And I don't frankly have a problem approving a budget and giving a CEO some wiggle room within that budget to make decisions about priorities. So if I'll say operations would be a big priority for the organization, and you got to pay someone a little more to attract the talent you need to do what you're trying to do, that's fine, but that's built into the budget decision. And so maybe the CEO's got to do some prioritization and say, I'm going to forego hiring maybe a lower compensated employee so that I can bring on this high speed, low drag operations guy and pay him a little bit more. So the budget process to me is where the board exercises the most direct influence over stuff.
Yep.
Right? Whether it's programmatics or personnel. And that's why that budget and the preparation of that budget is so important. So when we talked a minute ago or an hour ago about asking questions, the thing that to me is not tolerable is to have the CEO come in or the management team come in and present a budget at a meeting at which the budget is supposed to be approved. And so it's sort of a cram down. I don't have a chance to see it in advance. Another good point. What do you send the board in advance of the meeting so that they can read it and digest it before they get there? I want to have a chance to ask some questions and inform myself about how that money is going to be spent. And that's a place where you can say, by motion, with consent of a majority of the board, I don't think we ought to spend this $50,000 for this line item in the budget. It's advertising. We don't need to be advertising. We need to put that in operationals. And that's how the board influences and makes policy decisions, governance decisions and does not delegate those to the executive director, but instead converts that budget into a guidance document, right? Because if you want to wade out of your lane on budget, then you got to come back to the board. So that's for me is the single most, other than hiring the executive director, for me, the most important thing the board does is approve and oversee the execution of the budget.
Skip, that's exactly right in my feelings. So I want to ask you this, because you and I have served in the same position with the same organization, and that is treasurer of the Louisiana Bar Foundation.
You just have a lot more money to play with than I did, Edmund.
Fortunately, we do. Unfortunately for us consumers, but fortunately for the grantees, we're
interest rate. It's an
really
interest rate joke, y'all.
Skip, talk a little bit about your perspective on the use of, in this case, the finance committee, as opposed to the full board. Really getting into that granular information at the committee level, and then coming back to your trusted colleagues at the board level.
So the beauty of being in a larger organization, and I'll draw on the Bar Foundation, Edmund, and I'll also draw on one of my other board-driven organizations. If you have the luxury of being able to have a finance committee or a series of committees that deal with different topics, that so much enhances the work of the board. And I think here is where you can also select people who bring a skill set for that initial cut and that initial granularity that you want to see in the budget. You're a good example of this. I was not a good example of someone who was well versed in budgeteering, but we appointed people to the finance committee who could do that and would do that. When you have the ability to have a committee, and look, it can be a committee of two who have a skill set that now allows them to do the kind of analysis that the board ought to benefit from. I think it's vitally important. It is just, it's more than just making sure the numbers add up. It's, you got with payroll and budgets and, and estimates. So how do you estimate the cost of doing these things? A committee structure, if you have an organization that's large enough to support it, is invaluable to the work of a board. And the more money that you are dealing with, or the more complicated, let me put it a different way, the more complicated the finances of your organization are, the more important that kind of a committee and the audit committee that we're looking at here can be. Because think about this, if you're going to get in trouble, and I mean that in the go off the rails, spend money inappropriately, somebody breaches a duty, it's going to be money driven. That's where that'll be the source of the problem at some point, probably. So you got to spend some time here. And this is a place where you want to be educated and you want to ask questions. If you're in a small organization, David's startup, and your budget is $50,000, well, that makes the financing and the budget a little different, right? But if you're sitting in Edmund's position as the treasurer of the Bar Foundation, and your IOLTA revenues this year are going to be north of 12 million. Yes?
More like 18.
So then and then when you start as the board also thinking about how much of that you allocate to grants, how much your overhead's going to be is real important, because we always have this philosophy of granting out as much money as we can, right? And being as efficient as we can. So how do you do that? And that's all going to be driven in the budget.
I just want to say for the grantees out there that we have implemented a plan to reserve funding as we go forward from this year in particular, to be able to, I won't say guarantee, but we will be able to address the funding needs for the next 3 to 5 years at a level that is commensurate with what we've been able to do this year, as opposed to where we might be when those interest rates drop and the revenues are back to what I would call a more normal, kind of looking scenario. So that's a plan that I've been working on with staff and that we presented to the board to be able to reserve funding to maintain in some sense.
Great idea.
Please, I know it's being recorded, so please don't mishear
Yeah,
what
you
I'm
might hear this,
saying.
you might hear this again, right?
But when you hear those extra, those outsized numbers that the revenue is, I certainly don't want anyone to think, as we've assured our colleagues on the Supreme Court, that we are sitting on this money. We are not sitting on this money. We are appropriately planning for the future.
Yeah, and to me, that's an excellent idea. I mean, we had this discussion with grantees, those of us on the grant committee last year when we saw a plus up in the available money, right? So you have to say, all right, look, we're going to be able to get closer this year to what you asked us for, but we're not sure about next year. So having a little bit of a safety net plan, Edmund, is a great idea.
Yeah.
I don't want to also downplay the importance of a budget in a smaller organization. I just think this is good. It's fiscal policy. Everybody ought to have a budget. I mean, it just, you can't do this like when I ask my daughter how much money's in her bank account, she says, I don't know. I got to go to the ATM and the bank will tell me how much money's there, right? That's not how this works. It's not, you find out you're out of money when the first check bounces. That's not a good plan. So no matter how large or small your organization is, if you're a director, a budget and a report at your meetings about where you are actual as opposed to budget is something you need to insist on. Your fiduciary responsibility for ensuring that the fiscal resources, the money resources are spent appropriately and as you have directed is really, really important.
Yeah, and Skip, that oftentimes is the sole measure by which a director will evaluate the performance of an executive director. Did they meet the budget?
Yeah.
That, I'm not saying
look,
that's not what all directors do, but some will simply look at the numbers and say, prepared a budget. There was nothing extraordinary that happened throughout the year to cause a problem that we all experience, say an insurance collapse or anything like that, and either did or did not meet the expectations of the budget.
Yeah. Yeah. I mean, I think that's got to be on every meeting agenda and it's got to be a presentation to the board at every meeting.
Yeah. And I do want to say this and I know in larger organizations, oftentimes the timing of board meetings and the schedule is not such that you are looking at, say you have a board meeting on March 15th. You may not be looking at the year financials ending February 29th, right? It does take some time in more complicated scenarios, as we all know. So you may be looking at January numbers. You could be looking at December year-end numbers. I mean, it also depends upon the ability of the organization to complete its work. A lot of directors would say, well, these are three-month-old numbers. They're stale. They don't really tell me anything other than what we did at that point in time. Well, that's okay too. That is still timely review of financial information because it does take an appropriate amount of time to prepare and move forward. And I think that's where having an active executive committee or an active finance committee is so important, because at least as a director that there are colleagues who are putting their eyes on the most current information as it is developed. And that gives a lot of organizations, I know particularly in our own organization, a lot of assurance because of the qualifications of those folks who sit on that finance committee. And I feel the same way about the Bar Foundation board, and this is prior to my service on the finance committee. That those folks saw the numbers in the interim between the January meeting and the April meeting. I knew that there was February, and March were being looked at by someone else, so that we were getting really good information, but also having really good monitoring process as we move forward. So I know.
Absolutely. I was going to say before, and we're maybe getting close on time, and there may be some other questions, but kind of to that point about information sharing, the fact that your bylaws say you meet monthly or you meet quarterly does not mean that there can't be information sharing in the interim. I kind of like getting an email, just even if it's something, guess what? We got a grant from another source, or one of our people did something really spectacular. We're going to blast that out to the media. Or there's been something even bad, particularly if there's something bad that's happened. There's nothing wrong with communicating that to the board between board meetings. You don't always have to be sitting in the same room looking at each other. Doesn't make it any more or less relevant. And then the other part about that is you've got to establish a rhythm where you're going to get the information that you're going to talk about and deal with at the board meeting to the board members in advance, sufficiently in advance of the meeting, so they at least have a chance to look at it and digest it before they walk into the room. It is just not fair. And the one or two times I can remember really being put out with staff, not Bar Foundation staff, but was when you walked into a meeting and you were presented with, for example, the budget, and we're going to explain the budget to you, then we're going to ask you to vote on it. We're not going to, if I'm chairing that board, we're not going to ever do that. That's just it's not fair to the directors. It's not fair to the directors who have this obligation, right? So, be communicative as much as you can with each other. And maybe you don't want to transact business by email, but you can certainly share ideas and have discussions by email or Zoom even between board meetings. And then document your meetings and have accurate minutes, because that can always be important later on. Edmund, I don't know if we have time to talk about audit. We can, if there are no other questions out there, for sure.
We do have a few more. We do have 10 minutes left, and I do appreciate everyone who has hung with us. I know that the numbers have dropped off a little bit as we're approaching the noon hour.
Yeah.
I'll do this really quickly and just say, as Skip said, the budget, absolutely important. The timely review of financial information, as a director, please be aware of that. And oftentimes it's, have I seen financial information in a while? Maybe it's time for me to make a request. And if your organization is appropriately sized and capable, engage an auditor. And the auditor should report not to staff, but to an audit committee of directors. They are the ones who hire and direct the auditor. They will be responsible for answering questions. And that does mean, in some instances, a little bit of inefficiency in that they're filtered through the audit committee to get to staff who has the information. And then there is a great toolkit, and we used to have a link, and Renee and I will circle back to see that if we can get that. The AICPA Audit Committee Toolkit provides a lot of great information for volunteer boards as to how to conduct an audit and what it is that needs to be looked at from time to time. I did just want to say, on an audit, please, as a director, do not rely upon the audit to find criminal wrongdoing or any type of malfeasance. And I know, Skip, this is one that we talked about quite a bit. That's not what an audit is designed to do. An audit is designed to determine if you're appropriately reporting the information that you have, meaning they are going and pulling particular files, particular information, and seeing that it's all done the way that it's supposed to be done. And here you have on this slide, what is the audit? Yes, right. It's an examination of your financial statements, They are not creating anything. They are reviewing what the organization has produced. You're attesting to the fairness of the presentation of the financial statements. That means in the audit process, were they given the information that they needed? Was it a cooperative effort as opposed to uncooperative effort? And auditors will disclose that to the board. But it is not guaranteed to find any kind of fraud, and they certainly do not pull every single transaction of the organization. They may look at 10 reimbursements. They may look at 5 accounts payable. It just depends. And when they look at that, they make sure that the backup documentation is there, and they make sure that it's reported in the places that it is supposed to be reported in the financial statements. And then they come back to the board and they say, your financial statements are in compliance with generally accepted accounting principles or whatever standard it is that they are auditing to. Skip, anything else on that?
Yeah, I would, the audit, this is one place where the board does
Very active.
direct and not just provide guidance to management. This is an arrangement between the board and the auditor, not something that the executive director or the CFO is involved in, except to cooperate with the auditor in providing information. Now, the auditor, if you ask them to, will take a look at and give you advice about things like internal controls.
Right.
So in your organization, do you want the executive director to sign all the checks? Do you want the treasurer of your organization to sign checks? And if so, does the treasurer live within 100 miles of your organization, or how are you going to do that? Credit cards, debit cards, anything dealing with internal controls, the auditor will help you with that, but only if you ask. And frankly, the either for-profit or not-for-profit organizations that I think have been the most successful ask that question about every 3 years.
Yep.
So while you're out there auditing, take a look at our internal controls and let me know if I can sleep at night. Do we have enough? Should we have 2 people signing checks over $10,000? Should one of them be the treasurer? Just tell me how that's working, because the old adage is you don't want the same. This is a condemnation of human nature, I suppose. You don't want the same person sending out the bills, collecting the money, putting them in the bank, paying the bills, and reconciling the bank statement. That's just a recipe for disaster at some point, folks. So how do you split that up, and how big is your organization, and how can you do that best? Auditors are great resources. But when you have an audit committee meeting, it is the audit committee of the board and the auditor. And what you want the auditor to say is, we are presenting you a clean audit. That's a term of art. That should be music to your ears, which is the auditor's opinion that there were no material deficiencies in the way the financials of the business have been handled. If you have a management letter where they start pointing out deficiencies, and you don't do something about it, that's where you get close to breaching a duty, right? Because now someone has called to your attention a problem within your organization, you need to address it. And so the audit committee, for me, if you can have one, and if you can't have a committee, the board can be the audit committee,
yeah.
right? So, but it is a hugely important function. And for the chairs out there, one of the things you need to make sure you ask about and you get it every year, where you have auditable financials. So,
yeah, it's exactly right. And the size of many of your organizations is not going to be conducive to being able to have segregation of duties or things of that nature. So you will, in some cases, get the management letter, and it will say you don't have enough people on staff to open the mail, make the deposits, input the information into the system. That typically is a 2 or 3 person kind of transaction that takes place, so that no one person is getting the check, copying the check, putting the check in the bank, and then making sure that the deposit is reported appropriately.
Absolutely.
You just can't do it. But it is the one area we see most reported in management letters, and it's the one area where even auditors and outside folks looking at your audit, they completely understand that issue. So you do want to have a little bit of board input into that process. It also goes to the check writing, the size of the checks, the amounts of the checks, who's At what point do you need two parties? At what point does one of the parties need to be a director, someone who's outside of the office? Those are very common issues. And I would say to you as a director, this is nothing to be concerned about. It is certainly something to be aware of.
Yeah.
And then
So-
I know this is one of Skip's favorite topics, and we don't have time to talk much about it, but just make sure that the payroll taxes are paid.
Oh, yeah.
Because there are penalties. There are penalties that are applicable to you as a director if payroll taxes are not paid. And there have been some unfortunate publicized cases in the news about this, organizations, both for-profit and nonprofit. These are never good circumstances, and typically there is a lot of financial either mismanagement or simply just trouble going on in the background when folks are not paying their payroll taxes.
Yeah, somebody going to jail. So if I could, I don't know that do we have any questions to answer?
No questions in the chat.
Okay. So if I could take just a minute, when Edmund and I look at this, when we do this, we say, how in the world are we going to talk for 2 hours? Well, now you're all convinced that both of us were vaccinated with phonograph needles and we don't know how to shut up, right? Because we didn't get through some of the stuff that we enjoy talking about, which is relationship between the board and the executive director, recruiting directors, raising money for your organization. There's an awful lot into this director business. So I think I'm not planning to go out too far on a limb here, Edmund and Renee, but if any of you have any follow-up questions, or if there's a topic that we didn't get to that's in the materials and you want to set up another one of these sessions to bore down a little deeper, I'm certainly in. I know Edmund would be in to do that. And the same thing with your boards. We took this little show on the road when we first started it. But if your board wanted to have a session for a little while with us, just to talk about your board, I'm certainly happy to help if that's something we could do. And then last but not least, it's part of the fiduciary duty that the Bar Foundation board is aware of and carries out. Sometimes when we do a grant, I think this is still true, we'll put some conditions on it, right? So don't get all in an uproar about the conditions. The conditions, when you see those, are a reaction to something we see in the grant process. And it's a condition that gives the board of the directors of the foundation a check on its fiduciary duty with respect to your grant. Sometimes we'll come visit with you to help you or to ask some questions about that. That's part of our fiduciary duty, right? So it's not meant to be accusatory by any stretch of the imagination, but we at some point several years ago realized that if we had a question or a problem or potential problem with some activities in a grantee's business, we needed to address that. Now, we tried to go out and fix it. That's the address, right? It's not deprive you of money. It's to go fix your problem if you have one. And so if you think you have a problem, let us know. No harm, no foul, right? We can't do it anonymously because we got to come help you. But to me, that was and that's what kind of led to this. This to me, other than being able to put money in the hands of you guys to do great things, helping you refine your organizations and the way you govern and the way you do business has been a real joy for me and a reward for me to be part of. So, take that for what it's worth. But remember, as we are lecturing you about fiduciary duty, we have one too. And so when you see things like that coming from Renee or others, and you get a letter signed by the executive director or the chair that says, we're going to fund this monthly, for example. We're doing that as part of the exercise of our fiduciary duty. So with that, I'm going to shut up. Edmund, I'll turn it back over to you. Thanks for the invite to participate, as always.
Well, Skip, I couldn't do it without you, and I appreciate. We've, as you've heard now, Skip and I, we went back and looked the other day, and we first did a similar presentation like this back in 2009, and we've done it almost every year since, and in some cases multiple times a year. And it's always different. We find different things to talk about or focus on. We carry it on a little more conversationally as we did this time. Clearly there's a lot of room to provide support. And again, as I said, I feel a little bit responsible for this grantee and staff training committee that has been incepted and has been so successful. I appreciate the fact that almost 70 something of you were on the call today and had shared your time, shared some very interesting and important questions with us, which I think drove us in different directions to be able to respond. I, like Skip, would say happy to provide any other additional information. Skip and I, as he said, we've done one-on-ones with particular organizations at their request. And also that, I won't speak for Skip in this regard. I'll be here next year. Renee will probably be here next year. I'm pretty sure I can convince Skip to come back next year. And what we will do is hone it down again, and we'll get to some of the topics. But your feedback is so important to helping us craft and structure the conversation in a way that is most beneficial to you. And so please, 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 I know Renee is going to follow up with questions, ask for your comments. Please let us know. We appreciate it very much. And we thank you for everything that you do on behalf of your organizations and certainly on behalf of the Louisiana Bar Foundation, and hope everyone has a great weekend. So thank you so much.
Thanks, guys.
Thank you, everyone.
Thank you, gentlemen. We
Thank
greatly
y'all.
appreciate it. Thanks again for everybody who was able to join us.
Thank you.
Thanks.